If you just opened a letter from an insurance company and saw the word denied, I know exactly what that moment feels like. Your stomach drops, your brain starts racing, medical bills, missed work, that aching pain that won't let you sleep. And now the company that's supposed to pay you says, nope. Here's the truth. A denial is not a judge's decision. It's the insurance company's opening offer, and that offer is zero. They're betting that you do nothing next. They're betting that you feel overwhelmed, you second guess yourself, and that you quietly disappear. Hi, I'm attorney Jason Marker, and I've been helping folks here in Illinois deal with this exact situation for over 25 years. Today, I'm going to show you immediately what happens after a denial in Illinois, why valid claims get denied all the time, and the step-by-step playbook to get your claim back on track. Now let's talk about what happens right after a denial, because the next few moves matter more than most people realize. What happens immediately after a denial? First, you usually get a denial in writing. It may come by mail, email, or even in the carrier's online portal. Sometimes it's a full letter. Sometimes it's a one cold paragraph that basically says, we're not paying. And the letter almost always does one thing. It gives a reason. The reason might be specific, like a policy exclusion, or it might be vague, like injuries are not related, is sufficient documentation, or liability disputed. In Illinois, insurance regulations require companies to give a reasonable written explanation when they deny a claim. And your first party claims, that explanation is supposed to point to policy language that they're relying on. There are also rules for providing a written explanation to a third party when a claim is denied. Translation, you're not supposed to get a denial that's just a smoke and mirrors. If the denial feels vague, then that's not the end. That's your cue to press for specifics. Second, once a denial is issued, the insurance usually closes the claim internally or moves it to lower priority. That sounds technical, but here's what it means in real life. Your life gets colder, calls take longer, everything gets shorter, and the insurance adjuster suddenly has nothing else to add. And that is exactly why your response has to be in writing, organized, and with a purpose. People hear denied and assume that there must be something wrong with their case. Not necessarily. Insurance companies deny claims for one simple reason. It saves them a lot of money. Sometimes the denial is legitimate. Plenty of times it's a tactic. They're testing whether you will fight them harder. Here are the most common denials I see in Illinois. First, they question fault. Even in a basic crash situation, they'll challenge that you were at fault or partly at fault. You get rear-ended on 290 near Oak Park, you go to the emergency room, and the other driver's insurance suddenly claims that you stopped too fast or changed lanes unexpectedly. That is not always a real defense. It's often a leverage move. Second, they play blame game, extenuating circumstances. If you've ever had back pain, neck pain, migraines, or anything in your medical history that sounds similar, they'll try to argue that the crash did not cause it. It just flared up or was something that you already had. Third, they attack the treatment timeline. If you waited a week or two to see a doc because you were busy, you hoped it would go away, or you could not get an appointment, they will call that a gap in treatment and use it to suggest that you were not really hurt. Fourth, why hide behind that policy language? Exclusions, notice, requirements, definitions. To a normal person, it reads like a foreign language. To an insurance company, it's a toolbox. Here's the important part. To identify which excuse they picked, you can build your response around that exact excuse. This is how denials get reversed. Let's separate two situations because this trips people up often. Situation one, you're dealing with your own insurance company like MedPay or collision or underinsured motorist coverage. Those types of claims are called first-party coverage. Situation two, you're dealing with the other driver's insurance company, which is a third-party claim. In both situations, you can challenge the denial, but the leverage looks very different. With your own insurance, Illinois has rules about how claims are handled and how denials are explained. And if the insurance delays or refuses vexatiously or unreasonably, Illinois law allows a court to award attorney's fees and costs or additional amounts in some cases. With the other driver's insurer, a denial usually means that they're denying liability, but they do not get the final word on what happened. A judge or a jury does. And either way, you can file a consumer insurance complaint with the Illinois Department of Insurance if you believe that insurance is acting unfairly or not following the rules. Now let's get practical because this is the part that changes outcomes. What you should do step by step. Step one, slow down and read the denial like a checklist. Do not just read it once and spiral. Read it with a pen. Circle the exact reasons that they gave you. Highlight any policy sections they cite. Write down everything you see and what's missing. Also, do not throw away the envelope. Keep it. The date matters when we're tracking timelines and communication. Especially if you talk to a lawyer later, they will need a copy. Step 2, build your own claim file because the insurance company already has theirs. If you have not already started a folder today, I would highly recommend you do that. Put in your crash report, photos, videos, witness names, medical records, your discharge papers, prescriptions, follow-up instructions, every email or letter from the insurance company, everything you get. Also include proof of missed work and lost wages like pay stubs or a letter from your employer. One small thing that helps a lot, start a simple pain and limitation log. Not a novel, just daily notes about what you can't do, what you hurt, what things you can't do, and what you're missing. Step 3, get clarity in writing, not in a phone argument. Call the adjuster if you want, but don't debate them, don't vent, don't try to win on the phone. Your goal is one thing, get them to put specifics in writing. Ask, what exact documentation is missing? What exact medical record do you need? What exact policy provision are you relying on? What exact fact are you disputing? Then follow up with an email after that recaps the conversation, the date, the time, what was said, what you're going to provide next. This creates a paper trail, and paper trails eventually win arguments. Step 4, you then fix the weak link that the denial is pointing at. Most denials fall into one of 3 buckets. Bucket 1 is missing information. That means you send what they asked for clearly in one package. Bucket 2 is causation. They're claiming your injuries are not caused from the crash. This is where a short letter from your doctor could be very powerful, a clear statement that the crash caused or aggravated your condition, based on exam findings and timing. Bucket 3, liability. They're blaming you. This is where photos, scene evidence, witness statements, and the police report really matter and can help. If you respond emotionally, then they will ignore you. If you respond with organized proof, the denial starts to look very risky. Step 5, put the case on a timeline because deadlines exist whether you like them or not. One of the biggest mistakes after a denial is waiting months before you feel stuck. In Illinois, many personal injury lawsuits must be filed within 2 years after the cause of action, with some exceptions depending on the situation. I'm not saying that you need to sue tomorrow. I am saying that you need to act like the clock is real, because it is. At a minimum, talk to an Illinois personal injury attorney early enough that you're not making rushed decisions later and that you're saving information correctly. Step 6, if the denial holds, escalate the leverage. Hire an attorney who can evaluate the denial. Is it a simple coverage dispute or whether the claims crosses into unreasonable conduct that can support additional remedies? If it's the other driver's insurance, the real leverage is the lawsuit against the driver because that forces discovery, sworn testimony, and a court schedule. And again, that means that you'll need to get a lawyer to do that. A denial letter is easy. Defending the case in court is expensive. That's why many denied claims suddenly become negotiable when you show your lawyer shows up and is willing to push the process forward. All of a sudden, the insurance company listens. Most people hear lawsuit and picture a dramatic courtroom scene. In reality, it usually looks like this. First, the case is filed in the court where it belongs, like Cook County or DuPage County. Second, both sides exchange information in discovery. This is where medical records, photos, and testimony matter. It's also where you can force answers that you never get voluntarily. Third, negotiation gets more serious. Many cases settle before trial because the insurance can finally see the evidence and the risk. And if it goes to a trial, you get a judge or a jury making the decision, not an adjuster. Common myths that keep people stuck after a denial. Myth 1, a denial means that you have no case. False. A denial often means that the insurer wants to see if you will fold. Myth 2, it costs too much to fight back. Many injury attorneys work on a contingency fee, which means they only get paid if you recover money. Myth 3, the insurance company has the final say. No. Policies, statutes, and court exist for a reason. Myth 4, it's too late. Maybe, maybe not. But waiting always makes it harder, and deadlines can quietly end a case if you ignore them. Here are some quick suggestions on how to reduce the chance of a denial. Nobody plans an accident, but you can make your future case stronger. Get medical care early, even if you think it's minor. Follow the treatment plan if you cannot document why. Take photographs immediately and keep them backed up. Be careful with recorded statements and paperwork. If you do not understand what you're being asked to sign, pause and always get an attorney and advice before you sign anything. And keep everything. If you think you need to save it, save it. If you already got a denial, final thoughts on what to do right now. If your injury claim was denied in Illinois, I want you to remember this. The denial is a hurdle, not a dead end. Treat that letter like a to-do list. Identify the reason, build your file, get clarification in writing, fix the weak link in the evidence. If the insurance still will not play fair, escalate your leverage and get an attorney who knows the system and can fight back. Because the insurance company is counting on you to give up. You don't have to. If you want the next step, you've got to watch my video on what to do when your car is totaled and you still have a loan. That situation can wreck your finances if you do it wrong. And it's one of the fastest ways that people get trapped paying for the car that they can't even drive. Click it now. Protect your rights, protect your wallet, and I'll see you in that next video.